So what options are there? This guy's got a trademark problem. We're working on a clothing brand, so you're just talking about apparel.
Yep, everyone's favorite.
Dog Cruise, actually pretty related to our topic for the guest here.
Cool.
I've been creating designs, working on my website, Dog Crew with a K, related to social media handles, content manufacturers back in September this year. He filed one for in-use status, but discovered a competitor had filed a Dog Crew with a C, 2 words, with the ITU. I don't know ITU.
Intent to use.
Intent to use. Okay, after that in October. They go on to talk about some other stuff here. They apply for several classes, including those related to clothing.
Yeah.
And so, yeah.
This individual, they're screwed.
Oh, okay. Officially.
So, yeah. Based on if those facts are what they are, and it's clean as it sounds, you failing to go to market and also failing to file a trademark application prior to going to market allowed basically this third party to file a trademark application.
Oh.
So if they had filed an intent to use application in the fall or sometime in the summer, right, that would have held space at the USPTO and prevented this third party from applying for their intent to use application.
Yep.
I would say if this individual knows the third party, right, and there's some sort of agreement between the parties, right, that could be a violation of a non-disclosure agreement or some sort of proprietary information, in which case there's probably a different remedy available to this person. But yeah, that's tough. That's really tough.
Right. It's tough. And
or as Jonathan says, that's rough.
That's rough. Thank you, Matt.